This is Great Lakes Home Health Services, Inc., doing business as Elara Caring versus Brandy Van Duzen et al., docket number 20-154CB. This is the time set for hearing on cross motions, and they are pretty much, although each one doesn't contain all the issues the other one contains, they are truly cross motions in that they have something in common. So I'm going to, and that is the plaintiff's motion for partial summary disposition and the defendant's motion for summary disposition. So since they do share all the same common issues, I'm going to ask you to just argue them as one. So I'll give the plaintiff argument time, I'll give the defendant argument time, and then because they are cross motions, I guess I'll give you each rebuttal time, and then that'll be it. So these will all be handled together. Seems like everybody gets that, so we will get going right away. And first of all, could I have appearances for the record?
Good afternoon, Your Honor. My name is Thomas Davis, and I represent the plaintiffs.
Good afternoon, Your Honor. My name is Brendan Beer, and I represent the defendants in the matter.
Okay, Mr. Davis, you want to start out here?
Yes, Your Honor. And consistent with what Your Honor just said, these are interlocking to some extent. Obviously, when responding to defendant's motion, all the facts have to be taken in the light most favorable to Elara. So what I plan to do with the court's indulgence is to argue why I believe the undisputed record supports partial summary disposition. And then I will address, with respect to each of those arguments, why at a minimum, when you look at the facts in the light most favorable, there should at least be a jury question if Your Honor does not grant our motion.
Okay, just let me tell both of you before you even get going then. Bear in mind as you argue that I've thoroughly read the briefing and I studied that well in advance, and I'm always prepared, so you can keep that in mind as you argue. Go ahead, Mr. Davis.
Okay, thank you, Your Honor. So then I will be somewhat brief then, and I'm receptive to any questions the court may have, but let me start though with the first of the issues, which is breach of contract. Which we believe that there is no material dispute of facts that the contract has been breached. It's important to remember that there are two separate clauses at issue here, and we believe each one of the clauses independently, there's facts that support a breach, neither of which we believe really truly addressed by the defendants, and I'll get into that. So the first is the non-competition clause. Now, the scope of the clause states, and we have the full quote in the brief, but in essence, Ms. Van Duzen was not permitted to work directly or indirectly, alone or in conjunction with another person or entity that provided hospice care. That's the actual scope of the language, and that's where we need to start. Now, it's really no dispute of fact that she worked in conjunction with Caroline Hospice. She admits that she brought Caroline Hospice representatives with her to meetings with referral sources. That includes Mr. Mead, who was the CEO of all of the Caroline entities, and she brought him directly to the largest referral source she had at Elara, which was Sparrow Hospital, and she did so knowing that Mr. Mead was going with her to meet with her prior contacts at Sparrow Hospital for the purpose of pitching Caroline Hospice services. There's no dispute that Ms. Van Duzen did joint presentations and joint marketing along with hospice representatives. And as we've discussed, the two entities are tied at the hip. Over half of the lifetime referrals to Caroline Hospice have been referrals from the Caroline Palliative side. These are two very interconnected entities, and that is spelled out best, I believe, by the undisputed fact that when Ms. Van Duzen was creating her plan to work for Caroline Palliative, her goals specifically included bringing hospice representatives and introducing them to the referral sources that Ms. Van Duzen was going to be meeting with. That is in her own written plans for her position at Caroline Palliative. So the two entities, I'm sorry, Ms. Van Duzen.
Pardon me, Judge. I'm getting a lot of like muffled feedback from him. I don't know if he needs to turn his mic down or.
Maybe it's someone else who, no, the rest of everybody's muted.
All
My
right,
court recorder interrupted to say she's getting muffled feedback on your end, Mr. Davis.
let me see
And
if I can.
everybody else is muted, so it can't be them.
All right. I'm going to try to turn down my microphone and let's see if that works at all.
Yeah, but that's what she was thinking, that maybe that's the problem.
Much better.
She says it's better already. I'm sorry for the interruption. Go ahead.
Not a problem. And if it goes out of
I apologize.
whack again, please let me know.
Now I can't hear you at all.
I'm sorry. Okay.
All right, can we try again? Is this working?
Is that better?
It's still, I'm getting tons of.
Okay, so
feedback.
you're either really loud or you're so quiet we can't hear you.
All right, Your Honor, I've adjusted it again.
How's that, Susan?
Yes.
She thinks that's better.
Can you hear?
Yeah.
Okay.
All right, I'll leave it there, Your Honor. So to pick up where I left off then, so there's no question that at least looking at the language of the actual contract where indirect or in conjunction with Caroline Hospice is covered, there's no material dispute that Ms. Van Dusen did so. The second clause, and I'm going to come back to the defendant's motion, but the second clause is non-solicitation, and that is completely divorced from who her employer is. It states that Ms. Van Dusen cannot, again, directly or indirectly, alone or in conjunction with any person or entity, solicit former referral sources of a law. And for the same reasons we just discussed, that occurred. There's no dispute. She brought individuals from Caroline Hospice with her to her own referral sources. They admit this. Their defense is effectively, well, it didn't happen 100% of the time. It only happened a little bit, but it's a non-solicitation clause. There's not an exception for, well, I didn't solicit very much. So again, I think that the facts are undisputed, that there was a violation of the non-solicitation clause as written. Now I want to turn to briefly the argument that defendants raised. It's focused almost entirely on the argument that Caroline Palliative is just an entirely different entity. I see that Dr. Nicholas Keelhorn is in the room here, and that's the basis of their argument, that Caroline Palliative is just a completely separate entity. Dr. Nick Keelhorn is the person in charge of it, and so end of story, Your Honor. Well, that's not relevant. Really, the court doesn't even need to address that issue because, again, the scope of the actual contract says that Ms. Van Dusen cannot work in conjunction with another entity or solicit in conjunction with other people, and she did that. So we don't have to even address the issue of whether Caroline Palliative and Caroline Hospice are different entities, because that's not the scope of the contract itself renders that irrelevant. But as a matter of fact, if the court were not to rule in our favor, we have provided, and I'm not going to go through the whole list, but we have a full page in our brief of bullet points setting out numerous facts that support the argument that a jury could find that there is no actual separation, that every Caroline entity is owned by CEO Joe Mead. The record shows that Caroline Palliative, actually, Dr. Keelhorn's an employee of one of Joe Mead's companies. He's paid by Joe Mead's company. He doesn't take a salary from Hospice, from Palliative. They all have the same address. The employees cross over and work between all the Caroline entities. And we've set forth the case law and the facts, which we believe are enough to at least let a jury decide that the Caroline entities are not, in fact, kept separate, and that the veil should be pierced there. And so Ms. Van Dusen really was working for the Caroline Health Group. One interesting thing, if you go right now, Your Honor, to the Caroline Health Group website, and I don't know if this is something that changed recently, you can actually go to their career section, and they list on the Caroline Health Group website right now, they list Caroline Advanced Physician Services, which is what Dr. Keelhorn is supposedly the separate entity, and Caroline Hospice are listed as departments of Caroline Health Group right there on the website. And I can submit that to Your Honor if you want to see it. But again, I don't think we need to go there because the scope of the contract is such that Your Honor doesn't need to. And we believe that as a matter of law, there's been a breach of the contract here. Unless Your Honor has any questions on that, I'd like to move on to the next topic. And that's very briefly, we briefed that under the same contract, as a matter of law, the defendant Mr. Van Dusen is responsible for attorney's fees incurred in enforcing non-compete. Defendants did not even address this provision at all, did not address our argument. So we believe, again, if the court finds there has been a breach of contract, it should also find that as a matter of law, attorney's fees will be an element of damages, and that'll have to be determined after trial because they're still occurring. Third is tortious interference. Again, the elements of that are the existence of a contract, a breach of that contract, and an unjustified instigation of the breach. And we have cited case law, which I don't believe has been refuted or even really acknowledged, that it's enough when we're not talking about tortious interference with a business expectancy. That's a harder tort to show. But when you have tortious interference with a contract, it's sufficient if you solicit somebody for employment knowing that they have a non-competition agreement and knowing that that's going to cause a breach. And what are the undisputed facts here? Directly from Mr. Mead's testimony, he knew she had an agreement. He knew she had an agreement with Alara. He knew that she was concerned about it and that she had consulted her own attorney, and her own attorney gave her the advice that she believed that if Ms. Van Dusen solicited the same referral sources in the same territories, that she would be violating her non-compete agreement. Ms. Van Dusen copied her lawyer's email into an email that she sent to Joe Mead. And Joe Mead, who is a law graduate, but he's not an attorney, at least he's not licensed in Michigan as far as I know, told her, well, don't worry about it. I don't think that, it's going to be a problem. He never read the actual terms of her agreement, and he hired her anyway and admittedly put no limitations on her ability to solicit her former referral sources. And in fact, pretty quickly went along with Ms. Van Dusen personally to solicit her former referral sources for hospice. So we believe that those undisputed facts are enough to show tortious interference on behalf of Caroline, which Mr. Mead was the CEO of and acting on behalf of. But at a minimum, we think a jury should decide the tortious interference claim because of all those facts, which are in the record showing knowledge of and instigation of the breach. And finally, I'd like to address, and again, if Your Honor has questions here, I'm happy to take them, on the protectable interest, which really seems to be the focus of defendant's motion, is that we don't have a protectable interest here. And I'd like to address, there's two separate interests, and I'd like to go through either one of which would be sufficient to support a non-compete and a non-solicit in this case. The first is the confidential material. Now, we have explained, again, our reply brief sets this forth. We set it forth originally. Defendants say, well, we have no proof of that, and so we reiterated it for Your Honor. But Ms. Van Dusen, while she was working at Great Lakes, she was primarily hospice at the end. She actually, during her tenure, had sold all three lines of Alara services: home health, palliative, and hospice. But at the end, she was a hospice representative for the most part. During her time at Alara, she partnered with counterparts who worked in the other service lines. She collaborated with joint sales efforts at Alara. She regularly attended these business review meetings where other hospice representatives outside of her territory and her would discuss the potential leads, confidential information about referral sources, would discuss strategies, plans, what had been working, what had not been working with various referral sources. And all that was a very valuable source of confidential information about how Alara was going about trying to solicit these referral sources. And I'm going to get to that in more detail, but there's no question that we set forth all of these facts. There's no dispute that Ms. Van Dusen was involved in these quarterly business meetings, that she had access to this information, not just of her own referral sources, but those of others. And that we've cited the case law that shows that is sufficient. Having access to your employer's confidential information supports a non-competition agreement. Now, let's turn to the referral sources, because this is a very important issue. Now, frankly, there's been some attempt to try to act like this case is about something else, that this is about patients. I believe that the phrase that they put in their brief was that this is about soliciting patients, all of whom are now dead, which, was somewhat glib, but it has nothing to do with the reality of this case. The record is undisputed, and you can tell this just by looking at what Ms. Van Dusen's own duties are, is that the referral sources are the facilities. We're talking about, for hospice, hospitals, assisted living, sometimes individual doctors' offices. But we're talking about facilities which provide an ongoing source of patients, effectively make those decisions on what patients to refer. And they're the ones that make the decisions to make referrals in the first place. And those are, as the Florida Supreme Court said, and I think it's important to go to this, that's the lifeblood of this industry. There's really no dispute. I think if you look at the actual facts in the record, that is how this industry operates. Both at Alara and at Caroline, what Ms. Van Dusen's job was going to speak to the referral sources. She wasn't speaking to individual elderly patients. She wasn't selling to individual patients. She, Mr. Mead, her colleagues at Alara met with the executives and the other decision makers at these facilities who were making decisions on who to refer. One of the key things, and this is all throughout this bind, we've provided the court, I think, with several, maybe half a dozen or so examples of Ms. Van Dusen's work papers, where she is literally identifying the referral source, which is the name of the facility. She's identifying the key decision makers. She's identifying who the preferred provider is. And in some of those, she discusses, again, bringing hospice representatives to these referral sources, giving presentations to these referral sources. There's no question that both of these companies, both our client and Caroline, they solicit the facilities. And that's how they make their living. That's how they make their money, is that they get these referral sources from the people who make referrals, and they provide that service. Now, there's no question in Michigan that protecting your customers and the goodwill that you engender with your customers is a protectable business interest. And here, these are, in a very real and serious sense, these are the customers. These are the people that Caroline and Alara both go to get their referrals. They compete to become preferred providers. Now, yes, individual patients could decline, but that doesn't change the fact, which is, again, borne out by the facts here, that they are still soliciting the referral sources because that's where the value is. So while Michigan accepts this general principle for sure that goodwill is something that can be protected, relationships with your customers can be protected, every case that we found outside this context, and in particular the Florida Supreme Court, has held that in this industry, referral sources are perhaps the most important interest that a company in this industry has. We're talking about literally the source of the revenue for these companies, and that's clearly a protectable business interest. We think that, unless Your Honor has any more questions, I think that's rather clear. The only cases, I know that Mr. Beer is probably going to talk about these, but he cites a case where the word referral source is used in Michigan in an unpublished opinion. And I think it's important to address that right now, to the extent Your Honor has any concerns. This was in the title industry, not the home health and hospice industry. And it says two things that are really important for the court to take into account if that's what Mr. Beer wants to rely on. One, it says very specifically in that opinion, and this is unpublished, but still, this is definitely accurate, that in order to determine what is a protectable business interest, the court needs to look, it's an inherently fact-specific inquiry related to the business line. And in that case, if you look at, this is the Bartlett case, which I'm sure you're going to hear about more, but the Bartlett case was a title industry case. They called their referral sources were also known as the clients. And if you read that opinion, the courts found specifically that clients, that the referral sources were seldom sources of repeat business. It could not be more different than this case, where the entire thrust of the industry is to obtain repeat ongoing referrals from referral sources, here hospitals, assisted living facilities, and the like. So although Your Honor is going to hear a lot about that case, it really has nothing to do with this industry. The facts are completely different. And if you look at every court that's looked at this issue outside of Michigan, they've all been consistent on that point. And we don't think there's any reason for this court to go contrary to that decision. Unless Your Honor has any other questions, I think that the rest of the issues, as far as the scope of the non-compete, frankly, we've cited numerous cases that have consistently upheld 2-year restrictions. The Fulmer case, which actually defendants cited, but actually supports our position, held that accountants and insurance agents, they both build these same relationships of confidence with their clients. and that you can protect those confidences and that goodwill that's developed. And that was a 3-year and a 5-year non-compete respectively. This one's only 2 years. The Ruyacher case, I'm probably mispronouncing that, but that's the other case involving a former client of an accountant. And the Court of Appeals there, again, or I believe the Supreme Court, again, affirmed a 2-year non-compete for protecting the goodwill of and relationships with former customers when an employee moved on to another company. As far as the scope of this, really, it's a red herring. Ms. Van Duzen's territory at Elara is completely engulfed by her territory at Caroline. And to that extent, that's what we're addressing, is the fact that she was competing in the very territories that she had, that basically Elara had paid her to develop for, I believe, over a decade. I believe she'd been at the company for more than a decade, developing these relationships. So the scope issue is really red herring. I mean, this is right in the heart of her former territory and the same referral sources. And as far as the line of business, again, it's very narrow. Ms. Van Duzen, like I said in the brief, there's no question she's an excellent salesperson. She is more than able to use those general skills in any other industry, or in the healthcare industry, or in the home health or hospice industry, just not in the same territories where she was working for Elara and calling on those same referral sources. So again, these are kind of academic questions, because really Ms. Van Duzen's activities went right to the heart of what she was doing while she was at Elara, and they should be covered. No matter how the scope of the non-compete would be interpreted, it would cover this activity. Unless Your Honor has any other questions, I would just say on the rest of the issues that we haven't raised, there's the conspiracy claim. Again, we're not asking for summary disposition, but clearly we have a claim for conspiracy amongst the 3 entities, the Caroline entities who conspired to tortiously interfere all through the person of Mr. Mead. And of course, Mr. Mead, the theory that Caroline has been trying to advance is that, well, these are completely separate companies. Well, if they're completely separate companies, they were still clearly working together, and we think we've shown evidence to that effect. Unjust enrichment, again, they don't even address it. They didn't address it in their opening brief, in their opening response brief, and we think that's another issue that needs to go to a jury, because there's just no dispute. So unless Your Honor has any other questions, I would reserve the rest of my time for rebuttal.
All right, thank you. Mr. Beer? You're muted.
Sorry about that. Perils of technology. I heard you loud and clear at the beginning.
Wait. Can you turn your volume down? You're really blasting.
I can certainly try. Let me see what I can do. Is that any better, Your Honor?
Yes, that's much better. Thank you.
Okay. I heard you loud and clear at the beginning, and I'm sure you have read everything, so I will try to be brief in my argument as well, although many people have told me it's not my strong suit. So if you've heard enough or you have questions, please just interject and let me know. Having listened to Mr. Davis's argument, I think you can tell full bore as he can where I'm going with this. I understand that Mrs. Van Duzen signed an agreement in 2012, several owners of plaintiff ago. But the reality is that an agreement in and of itself is not the end of the analysis. Restrictive covenants are disfavored restraints on trade. They limit employee mobility, they stifle wage growth, they hamper entrepreneurship, and as a result, they are not favored. And Michigan law makes that very clear. We have a statute on point that says an employer can only support an agreement or a restrictive covenant to the extent it's limited to protecting the employer's reasonable competitive business interests. We have case law that says that they can only be enforced to the extent they're reasonable. We have case law like the case law in Mopal that says that a restrictive covenant must protect against a former employee gaining a, quote, unfair competitive advantage, close quote, with the former employer, but not prohibit the employee from using general knowledge or skill. And we have a federal government that recently, through President Biden, issued an executive order that intended to, quote, make it easier to change for employees to change jobs and help raise wages by banning or limiting non-compete agreements. It's widely understood that these agreements are utilized by employers for nefarious purposes, such as just restraining their ability of their employees to make more money or leave bad situations, or frankly, start new companies, all of which is negatively impacting workers and the economy in this country. And so it's important that this court take a look at what exactly it is the plaintiff has that it needs to protect here, and doesn't allow the plaintiff to make arguments that expand beyond the scope of that. Dr. Keelhorn is here. Caroline Palliative Care, PLLC, is which does business as Caroline Physician Services, is not a competitor of the plaintiff. The plaintiff, and Alera says this, quote, Alera is a provider of home health care, hospice care, and but for a brief period of time between September of 18 and April of 2021, palliative care. That's straight from their brief, which means that all periods that are relevant, because my client left in July of 2019, at all periods of time that are relevant, they did home care and they did. Dr. Keelhorn has submitted an affidavit that establishes the fact that defendant Van Dusen is an employee of Caroline Physician Services, has been since July of 19, and has never worked for anyone else. He has submitted an affidavit that Caroline Physician Services provides primary physician services to elderly individuals with complex health issues who have difficulty leaving their homes to see a doctor. And he has testified through that affidavit that they do not provide home health services, nor do they provide hospice services. And so this entity is not providing hospice care services that are competitive with that of the plaintiff. And this has been admitted through Tom Alcott, who was the director of hospice sales for the plaintiff and Ms. Van Dusen's direct supervisor while she was employed there, when he testified that palliative care and hospice are not the same thing. They are different services and separate and distinct service lines. The plaintiff didn't provide palliative care or physician services when Ms. Van Dusen left their employ. And that Great Lakes only recently started providing palliative care services, more than a year and a half after defendant Van Dusen left their employ. They admit the service line being offered by Caroline Physician Services is not an industry they were engaged in when Ms. Van Dusen left their employment, and they didn't do it for a year and a half afterwards. Likely after through the discovery in this case, they realized, hey, this might be a good idea. And so they took the case on, but it's not something that they did before. That's further elaborated by Rebecca Matthews, who was the regional vice president of hospice for the plaintiff. So that you know, plaintiff is a very large national hospice provider, okay? And this is the regional vice president of hospice who testifies there's a difference between palliative care and hospice care. A company providing palliative and visiting physician services is a referral source and not a competitor of the plaintiff. If an entity does not provide home care or hospice services, they are not a competitor of the plaintiff. And Caroline Physician Services, if simply providing palliative care and physician services, which is what Dr. Keelhorn has asserted through his affidavit they do, is not a competitor of the plaintiff. Before you can have a competitive business interest to protect, you at least have to show that you're in competition with the former employee's new employer, and they have not done that. They cannot establish that. In fact, they readily assert, yeah, we're not. We don't do those things. And in my mind, that creates a difficult situation for the plaintiff right out of the gate, and they recognize it. So what do they try to do? They try to come in and they try to say, well, we know that she's working for an entity that's properly formed, operates completely separately, is owned by Dr. Keelhorn, according to his affidavit, isn't in competition with the plaintiff. And they say, hey, yes, but Dr. Keelhorn refers business to Caroline Hospice, and therefore it's indirect competition. Well, Your Honor, we don't dispute that. Dr. Keelhorn acknowledges in his affidavit that, yes, I do refer business to Caroline Hospice, Caroline Home Health, Michigan. I do that because they do a great job. But I also refer hospice patients to any number of other hospice care providers, including on occasion Alera Caring, because that's what doctors do. And when I make that decision, according to his affidavit, I educate patients. I talk to them about hospice as a service. I talk to them about why I think they would qualify for the benefit. I talk to them about all the different providers that are out there that could provide these services. And then the patient makes a choice about what they think is in their best interest, and I issue an order accordingly. And I may send them just about anywhere for that service, Careline, Alera, or some other provider, depending on the needs of the patients. And he articulated within his affidavit what goes into that. If we're going to extend this so far, this agreement so far, to say that because Brandy Van Dusen worked in hospice, she can't go work for a referral source that may one day refer hospice business to a hospice provider, Alera or otherwise, that extends it to every facility that could potentially be a referral source, which, as Mr. Davis just said, is every doctor's office, every hospital, every assisted living center, anywhere where elderly patients are living or being treated by a healthcare professional. That is way too broad in relation to this industry. She has taken, Ms. Van Dusen, a deliberate attempt to accept employment with an entity that isn't in competition with the plaintiff. It does not provide hospice care services. It does not provide home care services. And in the words of their own vice president of hospice, is not a competitor. It is a referral source. I provided that deposition testimony. That's their vice president saying that. When you can't get your own vice president to say that the new employer for the defendant is a competitor, you've got a problem. Their own people don't support the proposition that this entity, Careline Physician Services, is in competition with the plaintiff. They overtly say it's not. There can't be a competitive business interest when the entities don't compete. And despite what the plaintiff, and so what they've done is they've spun on their heels and they've come in with this argument that, oh, well, I know they're separate companies, but they all operate together and maybe we can pierce the corporate veil. But as I cited in my reply brief, that requires evidence that there's some fraudulent purpose for the organization of these entities. And there's no evidence to support that here. There is no evidence to support it. Dr. Keelhorn operates a medical practice where he sees elderly patients. Sometimes they're hospice companies. And we have had, and they've cited this, instances where he's made referrals to Careline Health Group Michigan, the hospice provider. But I can go out and I can hold a seminar about the benefits of estate planning with an accountant and with an insurance agent, and they can talk about what they can offer, and I can talk about what I can offer, and it doesn't make me an accountant, nor does it make me an insurance agent, any more than it makes them lawyers. We're not in competition, Your Honor, and entities, until there's reason to think otherwise, should be treated separately. And what they're acting like it, we know she works for Careline Physician Services, but we think you should allow this to move forward, because while that entity is separate, maybe it's not really. And this court should not be doing that absent evidence of fraud, as we've cited in our reply brief, none of which they've come forward with. The second issue, and he touches on this specifically, is, and he says, what's our protectable business interest? And he said two things. One, if the employee has access to confidential information, that can rise to the level of creating a protectable business interest that would warrant the restricted covenant. And two, the relationship she's developed with these referral sources. The first problem is there is no confidential information when it comes to the hospice care industry or the medical industry in general. Hospice patients are by and large Medicare patients over the age of 65 and dying. As a result, the conditions of participation in the federal administrative rules control everything. They control who qualifies for the benefit. They control what those benefits will pay for. They control how much they'll pay for it. They regulate who can provide it. There is zero about it. And the standard of care for treating a hospice care patient is uniformed across the country. It's done the same way everywhere. There's no secret where you go to find hospice care patients. There's no secret who provides the services, and it is a highly regulated, highly competitive industry. Which brings us to the concept of, and you notice Mr. Davis didn't expound on what this confidential information is. He went directly to the referral sources. And I want to draw your attention to two things with respect to that, Your Honor. The first thing is Alera's own witnesses, Thomas Alcott, I'm sorry, I mispronounced that during his deposition a few times too. So if he's watching, I apologize again, Mr. Alcott. But Thomas Alcott testified, there's nothing particularly secret relative to Alera Caring's referral sources. Specifically, and I don't want to mess this up, he said the identity of their referral sources is widely known in the hospice industry. And doubt that's really terribly surprising, Your Honor. It's not that hard to figure out that to sell hospice care, you may want to go to where the greatest concentration of sick and old people can be found. I don't mean to be crass, but that's what hospice is. You go to care homes, you go to hospitals, you go to assisted living centers, you go to physicians, because that's where the access to these potential clients are. And that's the important piece here, Your Honor. Despite what Mr. Davis says, none of these companies generates $1 of revenue from a hospice referral source. None. Every single one of these is a method to try to get to the actual revenue source, which is the clients and the patients themselves. These referral sources don't generate any revenue, and they are rarely have any kind of exclusivity with respect to these referral sources. And you can see that if you look at Exhibit F to my reply brief. This is what's called the Trella Report. Because so much of the hospice industry is Medicare based, all of that claims data is public record. And there are companies out there that exist for the sole purpose of gathering that claims data and making it available to companies like Elara Caring, plaintiff, and companies like Caroline Hospice Michigan, so that they can, quote, according to their website, uncover referral trends. There's no secret about, and I attached Sparrow because that was admittedly Mrs. Van Duzen's biggest referral source when she worked at Elara. And what you learn from that report is, you know exactly how many people Sparrow Hospital is sending to receive hospice care each quarter, each year. You know exactly where they're sending them, exactly what market share every single one of these hospice providers has, including Sparrow Hospital itself, who keeps nearly 40% of these hospice referrals for themselves because they have their own hospice provider in-house. And so you can see right from the data, okay, Sparrow keeps about 40% for themselves. And when they can't, they have literally 10 or more other providers who are receiving market share from Sparrow each and every quarter. They're sending them to Hospice of Lansing. They're sending them to Elara Caring. They're sending some to us, some to Michigan Premier Hospice LLC. They're sending them where the patients themselves choose to go. And as you might imagine, they're doing everything they can to keep as many of those referrals in-house as possible.
I'm going to just tell you that I'm going to hold you to the same 20 minutes that Mr. Davis used, so you've got about 4 more minutes.
That's fair, Your Honor. So let me hit on the referral source issue harder. The Northern Michigan title case is, despite what Mr. Davis says, directly on point. In that case, what the court said is title companies receive the vast majority of their business from referral sources: lawyers, accountants, bankers, people of the like. And as a result, those are the places where they get the bulk of their business because there are very few repeat clients, meaning guys like me send clients to those title companies, but it's never the same person, right? I mean, there's a constant turnover. I make a referral a month, but it's not the same person. Same thing here. Doctors, hospitals, these types of entities refer patients consistently, but never the same patients because it's hospice. They wouldn't qualify for the benefit if that doctor didn't believe they were going to be dead in the next 6 months. As a result, there are no repeat clients. And what the court said is when those referral sources are readily identifiable, which as you can see from Exhibit F in my response, they are, and when the sources of those referrals are readily identifiable, those are not a protectable business interest. And the reason for that is when you seek to go that far, the employer is not seeking to protect its business because it's never done business with those referrals. It's seeking to prevent competition in relation to future business. That's all it's looking to do. And that's what they're looking to do here. By telling Ms. Van Duzen that she can't go back to these referral sources that any number of providers call upon to secure business because they think that's going to somehow be unfair competition. How is that possible when every single competitor is there? And the Northern Michigan title case also says that those referral sources and the knowledge of the things that they prefer and those kinds of things, yeah, that's not confidential information. That's stuff that you could learn from one transaction. That case, if you substitute doctors and hospitals and care centers for the lawyers, bankers, and title business for hospice, because there are no repeat customers, it's dead on point. And it comes from the Michigan Court of Appeals, applying Michigan law to the same statute that's at issue in this case. It is dead on point. There is no protectable interest in a referral source. And therefore, there can't be any violation here. To me, if they can't protect the referral sources, and that's what's really at issue here, and the case law in Michigan and the guidance the Court of Appeals has provided is dead on point. If she's not working for a competitor and referral sources aren't protectable, there's no basis to have the agreement in place in the first place. It's not enforceable as drafted, and Ms. Van Dusen is entitled to summary judgment. And every other claim that the plaintiff brings is derivative of that claim. There's not a violation of these agreements if the agreements are not enforceable under Michigan law and Michigan statute based on the Northern Michigan title case and its application of MCL 445-774A1. There can't be a violation that supports any of these other claims. That's the whole basis of those claims. We can't have tortiously interfered with a contract that's not enforceable. We can't conspire to breach a contract that's not enforceable. You can't be unjustly enriched by hiring an employee who doesn't have an enforceable covenant. Every one of these claims hinges on the idea that Ms. Van Dusen has somehow done something wrong. And those claims are not supported by the facts, even as loosely interpreted by an opposing counsel or the law in this case. I mean,
Okay.
To me, there's just no issue of fact or law at play that supports the plaintiff's claims, Your Honor.
Thank you, Mr. Beer. I'll give you a brief rebuttal then, Mr. Davis.
Yes, Your Honor. Just a few quick points. Mr. Beer said something that was very interesting. He conceded. He conceded the point of that Florida Supreme Court case directly on point here, that these referral sources that are being solicited are a method to get to the patients. Yes, that is the business here. And the disconnect, I think, in Mr. Beer's argument and what the record shows is that it's not as if Sparrow Hospital and these other entities are just picking hospice companies out of a hat at random. The companies are competing to say, look, you should send those patients to us. There's zero question. That is what Ms. Van Dusen did at Alara. That is what Caroline Hospice does. And that is what Ms. Van Dusen was undisputedly doing, even though she was allegedly working for Caroline Palliative. She was bringing hospice representatives with her to these meetings so that they could solicit for hospice. That's the fundamental disconnect, I think, in this entire argument, is that this is a business that is directed at obtaining referral sources and convincing these hospitals and other entities to refer clients, because that is how the companies make money. Ms. Van Dusen was not soliciting patients. She was soliciting referral sources. And that is a very key fact that the other courts that we've cited have looked at. These are, in effect, the customers. That is exactly how this business is operated. That is how Caroline operates. That's how Alara operates. And that's something that we shouldn't lose sight of. I do, again, if Your Honor is going to give any credence to this argument about Bartlett, which again is an unpublished decision, I would direct the court again, the page 6 in the Westlaw version, I don't know what it is in Lexis, but it says that referral sources are referred to by plaintiffs as clients in the brief. And what the court said, and I'm going to read this verbatim because I think it's very important, understanding that we have to look at specific facts of the industry. And this is a court, in any event, quote, in any event, according to the record, there are seldom repeat clients in the title business. Okay, so that's what the facts were there. This is not a source of repeat business. That is completely the opposite of the home healthcare industry. They are explicitly hiring Ms. Van Dusen to repeatedly, and if you look at these notes, she would have the facility profile document, she would identify the preferred referral source for hospice, and then she would go down the list, and every time she visited, she would have handwritten notes, one after another. She was going to the same referral sources over and over and over again, trying to convince them to send patients. The one last fact, again, you didn't hear any argument from Mr. Beer, and I think our point is that it should be conceded. You heard nothing, again, nothing that goes to the actual language of the contract. She cannot work in conjunction with hospice. She did. She cannot solicit Alara's patients, regardless of who she works with. She's doing it on her free time. She's not allowed to solicit our referral sources. She did. There's no question about that. And I just do want to go again because Dr. Keelhorn was brought up repeatedly. At a bare minimum, you heard Mr. Beer making a lot of argument as to fact, as to why he doesn't believe you can pierce the corporate veil. And I don't want to go and repeat all of these, but I think one of the key things is Joe Mead is the CEO of Caroline Palliative itself. We provided the court with the documentation from the LARA website, Michigan, the official filings with the state of Michigan. Joe Mead is the CEO of Holdco. CPC Operating, which is the operating company that operates Caroline Palliative. He is the CEO of Palliative. He is the CEO of Hospice. His spouse is a Holdco employee, and she was Ms. Van Duzen's supervisor while Ms. Van Duzen was working for Caroline Palliative. So we have Holdco supervising a palliative employee. That's a fact in the record. The doctors and nurses who work for Caroline Palliative also, in many instances, work for Caroline Hospice. The same employees are crossing over. The Caroline Health Group, I mean, that just really goes to the point. It lists these entities as departments of Caroline Holdco. That's the trade name. Caroline Health Group is the trade name of Caroline Holdco. And the last point I would make, because Mr. Beer said this, fraud is not the only way to pierce a corporate veil. And I quote, this is from the Green versus Ziegelman case. First of all, even the case Mr. Beer cites, it's fraud or other wrong, basically a misuse of the corporate form. It is not, this is again a quote from Green, it is not necessary to prove that the owner caused the entity to directly harm the complainant. It is sufficient that the owner exercised his or her control over the entity in such a manner as to wrong the complainant. And we pointed out in our response brief, we have it all in emails. Mr. Mead, who again, as the CEO of all of these companies, is allowed to structure this and place Ms. Van Duzen wherever he wants. He knew she was going to be soliciting hospice as part of her job duties, unquestionably part of her job duties. He said, don't worry about it. Your employer will be Caroline Palliative. We have that email on the record. So he used his authority as the CEO of all the Caroline entities to decide where to put Ms. Van Duzen, and expressly did so for the purpose of evading the non-compete. That at least raises a fact question on that issue of piercing the corporate veil. But again, I don't think Your Honor needs to get there because she's violated the terms of the non-compete on their face. So unless Your Honor has further questions, that's where I would end.
I don't, thank you. Mr. Beer, short rebuttal.
Thank you, Your Honor. I have three things to say in response to that. The Northern Michigan title case says there are seldom repeat clients, okay? In this case, you have the same scenario. Hospice patients don't repeat. Dr. Keelhorn makes lots of hospice referrals, many of them, admittedly, to Caroline Health Group Michigan, others to other companies like Lara. But one thing I can tell you is they are never the same patient. Those people go to those providers and then they pay. And the next referral is not repeat. It is an entirely new patient who has qualified for hospice services. There is even less repeat business in this industry when you focus on the fact that the revenue generators are the patients and the clients, not the referral source. There is even less repeat clients in this business than there is in title, because in this business, there are none. Okay. Secondly, there's lots of talk about Joe Mead and his involvement in these entities. Corporations have subsidiaries all the time. Those subsidiaries operate as separate and distinct entities. Alara itself is not ignorant to this. They have more subsidiaries than any company Your Honor will ever see. They do it themselves. And subsidiaries should be treated as the separate corporate entities they are. If I have XYZ conglomerate that has 19 different subsidiaries, and an employee leaves me and goes to work for one of their subsidiaries that does X service, I can't stop them from working there just because there's a Y subsidiary that this employee doesn't work for that does compete. That's not the way this works. She's entitled to leave and work for a different company in a different industry. And the fact that there's some other company out there Mr. Mead's involved with that might do something competitive somewhere else doesn't matter. It really, truly does not. This court needs to recognize the separate corporate existences, the separate medical licensure, and in the complete separation of these two entities that exists. She works for a PLLC owned by Dr. Keelhorn, an entity that can only be owned and operated by a doctor. Extending this agreement through employment with Dr. Keelhorn prevents her from working for any physician anywhere in the state of Michigan, if that person ever happens to refer somebody to hospice. Dr. Keelhorn said himself, Ms. Van Dusen doesn't participate in conversations with patients. She has nothing to do with where these patients, whether they end up receiving hospice care or where they end up receiving it. Lastly, Mr. Davis seems to want to talk about the fact that the Northern Michigan title case is unpublished. I've acknowledged that, Your Honor, but there's a reason that the Court of Appeals, which is where we're probably going when we leave here on this referral source argument, has come down and said referral sources are not protectable. And we can look at the Michigan Court of Appeals and what they say about the protectability of referral sources in light of our statute and move the case forward on that basis, or we can go look at a Florida Supreme Court case applying different facts to a different statute 2,000 miles away and applying it to a completely different hospice industry. Michigan has what I would call an open hospice industry. It takes people that long to get into the hospice business in Michigan. I can do it tomorrow if I like, anywhere in the state. In Florida, you have what's called a certificate of need state, meaning they've decided as a state that competition as it relates to hospice care is not a positive thing. And so we're not going to let people just get involved in hospice unless they can show us that the public is somehow underserved in one of our districts. And as a result, as I cited in my brief, and I gave you the support for it, Florida has less hospice providers in Miami-Dade County than Sparrow refers business to on a quarterly basis, despite having millions of residents and it being the largest population of hospice patients in the country, Miami-Dade. It does not operate its hospice industry in the same fashion we do in Michigan, where we value competition within the marketplace. And so trying to apply a Florida state case to this fact scenario, 2,000 miles away, I mean, to me, I try to give my clients the best consultation I can. And I've got a Michigan Court of Appeals case nearly dead on point that says these referral sources are not a protectable business interest. And
Okay.
so I'm not inclined to give a lot of credence to that Florida case, and I would suggest Your Honor should not either.
All right, thank you.
Thank you.
Well, first, a little background. There are 4 counts in the complaint. Count 1 is breach of contract. It's based on an employment agreement and a confidentiality and non-compete agreement. They're dated the same day. And under those agreements, there are non-solicitation and non-compete provisions. Count 2 is for tortious interference, which is brought against the Caroline Health Group only. Count 3 is for unjust enrichment, and count 4 is for civil conspiracy brought against all the defendants. The bulk of these cross motions deal with the breach of contract claim, and specifically the non-solicitation and non-compete provisions, so I'll start there. First of all, plaintiff requests summary disposition with regard to the non-solicitation clause of the contract. The non-solicitation provision provides, during the term of this agreement and following employees' voluntary or involuntary termination from employment with Great Lakes, employee agrees that she shall not, directly or indirectly, either individually or on behalf of or in conjunction with another person, organization, or company, contact or solicit any Great Lakes client, including but not limited to referral source patient, patient advocate, or family member, or any other source of Great Lakes business or business referrals for the purpose of soliciting the Great Lakes client to do business with anyone other than Great Lakes. For purposes of this subsection, Great Lakes client shall include a Great Lakes client at the time of the termination of employee. That's the end of the quote from the contract. So at least in the briefing, the plaintiff is exactly right in pointing out that the non-solicitation clause is a prohibition on Ms. Van Dusen's conduct, regardless of whether she's working for a competitor or not. And the analysis of whether Caroline Health Group, which provides hospice care, and Caroline Physician Services, which does not, are competitors, is just not applicable to the non-solicitation clause based on the language of the contract, which is where we always start. The plaintiff on this issue of non-solicitation points to Ms. Van Duzen's own deposition, where she acknowledges that she brought Caroline Hospice personnel, including the Caroline Group CEO, Joe Mead, to meet with the referral sources so they could solicit hospice referrals. In that, in some cases, she brought the hospice representatives to meet with the same people that she had solicited for hospice in the past. She also said in her deposition that the hospice representatives who went to these meetings went to obtain business for Caroline Hospice, and that hospice referrals were sometimes generated at the meeting, and that she, Ms. Van Duzen, facilitated these meetings, and that she made sure the key decision makers were present and either explicitly or implicitly vouched for the hospice provider. The defendants point to other testimony and argue that Ms. Van Duzen did not sell any hospice care at the meetings and always deferred to the hospice representative if the referral source had any questions about hospice, and that these meetings did not happen extremely frequently. Here, on this matter, the issue of whether, or I'm sorry, here the issue that's been presented is, I believe, a disputed issue of fact. Whether Ms. Van Duzen was actually working in conjunction with the hospice representative to get a hospice referral is an issue that the jury has to decide. There is, as I've indicated, evidence brought forth on each side from the plaintiff's evidence, and the plaintiff even puts it this way, that it's sort of like a wink-wink situation when she goes to the referral source with the hospice representative. In order to make that inference, a finder of fact would have to make the inference and decide whether they were actually working in conjunction with each other. The language in the contract does prohibit working in conjunction with each other. And the defendant also, their testimony that they point to is that the hospice representative, again, and Ms. Van Duzen remained separate and did not each participate in Ms. Van Duzen did not participate directly in the selling of hospice care, and for those reasons, I think that a jury has to decide that. So there is a disputed issue of fact with respect to the non-solicitation clause of the contract. The plaintiff also requests summary disposition with respect to the non-compete clause in the contract. And the defendants request summary disposition in their favor because the defendant's position is that the non-compete is just not enforceable because it's an unreasonable restraint on trade. Here, the issue of whether Ilara and Caroline Physician Services are competitors is relevant because the non-compete provision provides, during the term of this agreement and for 2 years following employee's voluntary or involuntary termination from employment with Great Lakes, employee agrees that she shall not, directly or indirectly, either individually or on behalf of or in conjunction with another person, organization, or company, engage in any self-employment, employment with any other entity, work as a consultant or independent contractor, or have full or partial ownership of any entity that provides or consults in providing home health care or hospice care within Great Lakes market area. Great Lakes market area shall be defined as those counties in which Great Lakes has received Medicare certification at the time of employee's voluntary or involuntary separation from Great Lakes. Defendants maintain that Caroline Physician Services does not provide any hospice care, and it's not licensed to provide hospice care, so it doesn't fall within the language of the contract, and Ms. Van Duzen isn't violating the contract by working solely for Caroline Physician Services. I think it is indisputable that Caroline Physician Services doesn't provide hospice care, but the plaintiff points to 2 reasons that Ms. Van Dusen is in violation of the non-compete. First, the contract says she may not engage in the activity either individually or in conjunction with another company. And second, the corporate structure is such that there's no appreciable difference between working for Caroline Physician Services and Caroline Health Group. I'm going to take a stab at describing what I see as a factual dispute is about. It's a little complicated, but DEM Holding Group, owned by Joseph Mead, owns Caroline Holdco. Caroline Holdco has a subsidiary, Caroline Holdco, I wanted to go in a different direction, owns Caroline Health Group. And it's Caroline Health Group that provides the hospice care. And that I think is indisputably a competitor of the plaintiff. But Caroline Holdco has a subsidiary, CPC Operating. Joseph Mead is the CEO of that subsidiary. They provide management services to Caroline Palliative Care and doing business as Caroline Physician Services. Dr. Keelhorn runs that operation. He's referred to as the owner. He's treated as an employee. And actually, Caroline Palliative Care pays management fees to CPC Operating for their management services. And CPC Operating pays the employee, Dr. Keelhorn, out of those management fees as the employee of CPC Operating. And it's that Caroline Physician Services, Dr. Keelhorn, for which Ms. Van Dusen works. So I hope that I got that right, but I think that illustrates the factual dispute here, whether Ms. Van Dusen worked in conjunction with another company or whether the corporate structure is such that there's no difference between the two. Either one of those theories, I think, are both factual disputes for the jury. So in other words, the plaintiff's version that Ms. Van Dusen accompanied hospice providers from Caroline Health Group when meeting with referral sources constitutes, again, that wink-wink kind of arrangement, versus the defendant's version that Ms. Van Dusen and a hospice provider went there together, but Ms. Van Dusen offered no information about hospice services and always deferred to the hospice provider, are just competing versions of the facts. And I can't accept either one as true without fact-finding. And that's particularly true since just to accept plaintiff's version, an inference has to be made that there's some kind of a wink-wink understanding. And the second theory about the corporate structure, I think also takes a fact-finder to resolve whether in fact there is no appreciable difference between the two providers and whether they acted as one. I will say, and maybe I shouldn't say this, but I don't think piercing the corporate veil is the correct framework for that. Piercing the corporate veil allows the corporate protection to fall away and liability to attach to an individual, or I suppose it could be another company. But it's a method of attaching liability. It has to be pled in some form, and it's a path to liability. It does require a fraudulent or improper purpose. Here, I just see it as a factual dispute about whether Ms. Van Dusen was de facto acting for Caroline Health Group. But if the plaintiff wants to prove something more difficult than that, then, go at it. But there's a factual dispute either way. So I would not grant summary disposition in that regard. Now, the defendants say that the non-compete is overbroad and it's unenforceable because referral sources are not a protectable interest, they're not confidential, and that Ms. Van Dusen is being prohibited from using her own general knowledge and skill. This does not involve a factual dispute because a jury doesn't decide this. It's a matter for the court to decide and to assess whether the non-compete either standing by itself or narrowed complies with MCL 445.774A1. And in this regard, both sides, and I would add too, normally the court does it at the outset of the case when injunctive relief's being sought as to the non-compete, but that wasn't done here, and so I'm doing it rather late in the game. But nevertheless, the court has the ability to say it stands, it's enforceable, it falls, it is not, or it's something in between and it can be modified and tailored to narrow it and make it enforceable. So both sides agree there's no published authority in Michigan that addresses referral sources as legitimate protectable business interests, but we do have a couple cases to work with, and as far as Michigan cases go. And they're at least helpful for either what they do show or what they don't show and how they're distinguished. So the first one is the Follmer case, F-O-L-L-M-E-R, and that's the Michigan Supreme Court case from 1984 that I think both sides have cited perhaps. And I want to talk about this case because I think it illustrates only that exploiting confidential information is not necessary in order to have an enforceable non-compete, but it can be part of an enforceable non-compete. So in Follmer, the employee had a contract that required the employee to pay his employer for the goodwill or the business in respect to a client or a customer if the employee rendered services to that client or customer within 3 years of termination of employment. And the court held that the contract was not an unreasonable restraint of trade because it protected confidential information, including information regarding customers. And the matter was remanded for determination of whether the employee actually had access to confidential information that provided him with an unusual opportunity to, as they put it, obtain the patronage of particular clients of his former employer. So the Supreme Court in that case used access to confidential information as a means to limit what would otherwise be a very broad restraint, because the restraint didn't limit it to confidential information. But that's how they limited it. And they explained it rather well, and this is in footnote 15. A party who develops or possesses confidential information or trade secrets, which are not at issue here, belonging to his employer should not be allowed complete freedom to terminate his association and then use this very knowledge to undercut the employer who had taken him into his confidence. This conduct, which amounts to a virtual stab in the back, gives a competitor an unfair advantage and is inconsistent with our principles of fair play. And of course, they're citing another federal case, but that's what they say in footnote 15. But I think we've learned too that access to confidential information is not the only way that a non-compete can be enforced. And that takes me to the case that we've called either Bartlett, B-A-R-T-L-E-T-T, or Northern Michigan Title. That's the unpublished Court of Appeals case from 2005. This was a non-compete clause that prohibited the employee from engaging in the title insurance business in Charlevoix County for a period of 5 years after termination. And that was unenforceable because it completely prohibited the employee from engaging in the title insurance business, which amounted to just a restraint on competition. But here's what the Court of Appeals had to say about the non-compete. Maybe I got something a little different out of this than the attorneys, but this is what I read that they found as their criticism with this very broad, no work in the title insurance business for 5 years, this very broad non-compete. They say, first of all, the employee would not be permitted to obtain referrals from sources that had never had a relationship with plaintiff. The employee would never be able to offer title insurance services to clients who never had or never would have given business to plaintiff in the first place. There are seldom repeat clients in the title insurance business, and business is developed through referral sources of which there are many and which are readily identified in the community. So while the Fulmer court used confidential information as their way of validating non-compete, the Bartlett case or the Northern Michigan title case didn't use confidential information. They looked at these other factors, and as a matter of fact, they said the confidential information is a claim that stands alone. So they didn't even take that into account the way the Fulmer court did. But in any event, I think those factors that the Northern Michigan title case pointed to are valuable. And so from those cases, Fulmer and the Northern Michigan title case, I take the following. Referral sources need not be confidential in order to enforce the non-compete. And I think in this case, they aren't. I'll talk about that maybe in a minute, but there is other confidential information that go along with the referral sources in this case that I think is at issue here. Unlike Bartlett, the non-compete, or unlike Northern Michigan title, the non-compete here is limited to hospice care and to hospice care in the Great Lakes market area, which is the counties in which Great Lakes has received Medicare certification at the time of Ms. Van Duzen's separation. So it's distinguishable from one of the factors in Bartlett for that reason. Also, and this is an important one, there may not be repeat clients in hospice care, but there most certainly are repeat referral sources. And this was described in the deposition testimony. It was described in deposition testimony as facilities having not only preferred providers that they would go to again and again and again, but in some cases, even exclusive providers. So one single provider that facility would always go to as a referral for their patient, as a provider for their patient. So developing a referral source in this case has potentially long-lasting rewards, and the plaintiff does in fact compete to achieve that. Now, there was a lot of argument in the briefing about whether referral sources are confidential or not. I reviewed all of the deposition testimony that both sides pointed to, and even the testimony that the plaintiff pointed to, and I just don't think it supports that just a referral source by itself is confidential. It was explained by various different witnesses as you walk in the door of a facility and they ask to talk to someone that would be relevant to what you're there for, and they give you someone, and maybe then you work through it a little bit from there and get to higher levels of management. So yes, can you open up a phone book and see for a facility who it is you need to talk to? No. But is it a secret? No. You just go to the facility and you start asking questions, and that's how it was described. But it was also described in the testimony that developing a referral source and getting that coveted spot of a preferred provider or even an exclusive provider, it involves much, much more than just walking in the door and trying to drill down on who it is you need to talk to. And one of the ways that it's done is, well, developing the relationship and working that source and doing it repeatedly. And I think even if we got to that point, it could be argued that that's Ms. Van Duzen's talent and her skill, no doubt, as an excellent salesperson. But there's even more to it than that, because there was an exchange of company information where Ms. Van Duzen obtained information from other account executives even about the referral sources, what works, what doesn't, and what strategies can be undertaken to improve business. So that's much different than the Northern Michigan title case. And having acquired the information and having built relationships with referral sources that grow into preferred provider or even exclusive provider status, using the resources that were available through the plaintiff makes the non-compete in the area of hospice care for the counties where Great Lakes has Medicare certification a reasonable restraint on trade and a protectable business interest. Again, like going back to Fulmer and footnote 15, you can't use the confidential information to undercut the employer who had taken the employee into their confidence, and that amounts to a virtual stab in the back and gives the competitor an unfair advantage and is inconsistent with our principles of fair play. So I do not find the non-compete for that reason to be unenforceable. Now, there's some fine tuning that could be done on it, and I may agree with some of the things that the defendants point out. They say that the line of business restriction is unreasonable. The contract prohibits employment for any entity that provides home health care or hospice care, and defendant argues that it should be narrowed to hospice care only. I agree. Even though the plaintiff says that Ms. Van Dusen sold home health care, hospice, and palliative care, the deposition testimony doesn't really support that. The plaintiff directs me to Ms. Van Dusen's deposition at page 35, but she says she never sold home health care. She says, and I'm not sure I know what this means, but she says she, quote, gathered the information and sent it in, end quote. And then she says, but she never sold home health care services. And so for that reason, I think it does have to be narrowed. And also, palliative care wasn't even sold by the plaintiff at the time of Ms. Van Dusen's separation. So I think it has to be further narrowed as well. I agree again with the defendant that it should be narrowed to hospice care only. And finally, the defendants say that the duration is unreasonable. The duration of 2 years is not unreasonable. There's many reported decisions holding that 2 years on a non-compete is not unreasonable. I won't just rely on that though. I think it probably has to be judged against the facts of the particular case. And here, given the testimony about the development of relationships with referral sources and the evolving into a preferred or an exclusive provider, 2 years is not unreasonable. And then the tortious interference, a jury could find that Ms. Van Dusen breached the contract. Therefore, the defendants aren't entitled to some summary disposition on the tortious interference. But I cannot find, I also cannot find as a matter of law that Caroline made an unjustified instigation of a breach of contract, because the jury has to decide if there was a breach, and even if there was, whether Caroline unjustifiably instigated it. As to the civil conspiracy, the defendant says Ms. Van Dusen can't conspire to breach her own contract. The plaintiff says that the claim is against the 3 Caroline entities. If memory serves me correctly, it actually is against all defendants, but I'll take what the plaintiff says as a cure on that issue about breaching your own, or conspiring to breach your own contract. With respect to unjust enrichment, an implied contract claim can only be made where there's no express contract. There's an express contract here. There is no basis for an unjust enrichment claim. And then the contractual attorney fees is just simply premature, given that the breach of contract claim has to be decided by a jury. So I'm denying the plaintiff's motion for partial summary disposition. I'm denying the defendant's motion for summary disposition, except with respect to the things that I've mentioned. I guess that would be there's no unjust enrichment claim, and I am narrowing the scope of the non-compete to comply with the law. And I will need someone to volunteer to submit an order that reflects for the reasons stated on the record.
I will volunteer, Your Honor. I was taking extensive notes, so.
Great, thank you. And in case you forget, I live streamed it on my YouTube channel, and I leave those recordings up so you can review.
Oh, thank you, Your Honor.
Thank you. And that will conclude this hearing.